Thank you. And thanks everyone for attending. And I'll tell you just a little bit about myself. So I'm an attorney. I've been in practice for 22 years. I was at big firms for a while, and 6 years ago, I took all my clients and just started my own firm, which has been wonderful. So my presentation today is Wealthy or Not, Your Estate Matters. And what it really does is it explains the fundamental concepts of estate planning, which in its simplest form is a will, a financial power of attorney, a medical power of attorney, and directive. And I'm going to talk about those concepts. It's called Wealthy or Not because it truly does apply to every single person. So whether you have absolutely nothing, or you're a billionaire, or like most of us, somewhere in between, all of these, you have to know these fundamental concepts first before, in order to be making decisions about your own estate plan. So let me jump in. But before I do that, I definitely want to take questions as I go through. So I will pause at every subtopic and check the chat and kind of open up the floor to people who want to ask a question, just using the audio feature. And the Savvy Ladies team is going to make sure that we don't get audio when we don't want it, and that we can hear you when we do want to hear you. So I will leave that up to them. Okay, and let me jump in here. And I know we're getting new people kind of jumping in all the time. All right, I'm going to talk about, so here's kind of the syllabus for today. What happens if I do absolutely nothing, right? If I have nothing in place, what happens? So some people will say to me, oh, I don't need a will, I don't have anything, or something like that. We're going to go over exactly what happens if you don't have any sort of legal documentation in place. And then you will be able to decide for yourself if you need to do something or not. We're going to talk about incapacitation issues, meaning, if I cannot act for myself, how do I name someone to act for me? And that's the powers of attorney and medical directives, those kinds of things. We'll also talk about, what is your estate? When we say that, what exactly do we mean? What are your assets? What are your liabilities? Because there's a lot of misconceptions about that. Lots of people will say, I don't have an estate to plan. And lo and behold, when you kind of take a look at what you do have, you probably do have more than you think. Or people think that certain things that they own aren't really assets, or something like that. So we'll go through all that. We'll go through types of property, and then we'll talk about costs, fees, and taxes, because people always want to know, am I subject to taxation at my death? Is there an inheritance tax where I am? What on earth is probate, and why is everyone so afraid of it? And is probate expensive, and what is that about? I will only briefly mention revocable trusts, but at least that they will come into play. And hopefully, if we have time, I'll be able to go through kind of what happens when we die, when we have that will in place, what actually happens. And that's called estate administration, or if you have a trust, it's called trust administration. So let's jump in and get started. We don't have a whole lot of time here. What happens if I do nothing? Okay, so if someone dies without a will, which the majority of people do, it's about 60% of the population will die without a will. Why? Number one, a lot of people think that they don't own anything. And even if you don't own anything, a will still really helps. And secondly, a lot of people will say, well, I don't have the money to hire an attorney to do a will. And that's true in a lot of instances. And I will tell you, when someone calls me up and they really, I don't want to take money from people who really can't afford to be paying an attorney just to get a will in place. There are forms that are absolutely valid that I encourage people to use, okay, as a will. And they are form wills. They are perfectly legal. You can get them at OfficeMax or Staples or some other place. Your powers of attorney, those things, everything we're going to be talking about today, those things are accessible. So for those of you who are saying, I can't pay $1,000, to get a basic kind of will in place and all of that, that just seems like an awful lot of money. You can still have all those things in place. It is perfectly legal. So that option is out there for you. I say this because I would love to get that 60% number much, much lower. It streamlines everything. It prevents disagreements, all of those things. Why is that? Okay, so what happens if you don't have a will at your death? That's called being intestate, meaning without a will, without a testate, a testament. And then testate is when you have a will, okay, in place. So right here, I'm using Pennsylvania law. I'm both in New York and in Pennsylvania. I practice in Philadelphia and New York. And so here's a sample law of intestacy in the state of Pennsylvania. Every state has its law of intestacy that says, okay, if someone dies and we've got property of theirs, what do we do with it? And so that's what the law of intestacy says. So another way to say that is, if you don't have a will, the state in which you reside at the time of your death has written your will for you. And that's the law of intestacy. So in Pennsylvania, just to illustrate, if you're married, but you don't have any children and you have no parents surviving, your entire estate will go to your surviving spouse. If you're married with no children, but your parents are surviving, this surprises a lot of people, the first $30,000 of your estate and plus 1/2 of the balance goes to your surviving spouse. But the rest, about half of what you have, passes to your parents. So a lot of people are surprised by that, especially the surviving spouse. This is why when people say, do I really need a will? Like, I'm married. Doesn't everything go to my surviving spouse? No, it does not. So here's a perfect example of where a chunk of someone's property winds up passing to their parents, not their surviving spouse. I think it's a weird law, but there it is. Okay. If you're married with children, whether or not you have parents living or not, doesn't seem to matter. The first 30,000 plus 1/2 of the balance goes to the surviving spouse. The rest goes to children. And people might say, oh, well, that's good. I'm happy with that plan. One, again, your surviving spouse may need that money, right? Your children, how old are your children? Okay, so you may have young people getting an inheritance that has not been planned for, that maybe isn't going to go into a trust or some kind of protective measure for that child. I always say it's fine if a 6-year-old inherits things, right? Because they're going to go ahead and it's going to be put in a protective account for them by law. But if a 22-year-old inherits things, that might be much, much worse, right? Because it's like they're young enough to not know better, and yet they're old enough to be a legal adult that they can do whatever they want with money. That's where problems arise. What if you're single? If you're single and you have kids, everything goes to kids. If not, then it goes to parents. If not siblings, then grandparents, then uncles and aunts, blah, 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 blah. Each state has an end to their laws of intestacy. So here we have about 7 sets of relatives that will inherit from you. And then if they run out of all those people, your money goes to the state of Pennsylvania. The state itself just takes it. So some states get the money pretty soon in the list of people. And some states, there's a laundry list of like third cousin, twice removed, whatever, who are all going to inherit or standing in line to inherit before the state receives your property. But, if someone is single and they didn't have kids and their parents aren't alive, and they're an only child or something, there really are, a fair number of instances where what you do have could actually wind up going back to the state. And you wouldn't want that, right? I mean, you would at least want a will to say, oh my gosh, at least give it to a charity or my best friend or, something like that. So this is just an example of what happens if you don't have the will. There are some surprises in there, and then there are just some things that you would not want. And the will is the place to write down exactly what you would want, and then it's going to happen. Okay. Okay, so I want to make another point of other issues that happen if you don't have a will. The other thing that a will does is that you pick the person who is going to administer your estate. There is an administrator of the estate. They're called an executor. When you don't have a will, it's called an administrator, but it's the same job. And their job is to say, okay, by law, who are the beneficiaries? What are the assets? Who gets what taxes need to be paid? And that person makes sure, has the legal responsibility to make sure that all of that happens. When you have a will, you pick your own person, right? It may not be a family member. It may not be your spouse. They might sort of be terrible with that kind of stuff. With a will, you can name whoever you wish. The laws of intestacy, it goes again by law. They're going to go to spouse first, then it's going to go to kids. It's all going to be relatives, and that may or may not be a fit for you. Minor children. Okay, here's a big issue. If you, God forbid, pass away leaving minor children behind, and minor children are generally under the age of 18, you want to pick a guardian for them, and you want to pick that guardian, and you want to list it in your will. Your will is the one place where you're going to make declaration of things that you want to happen. All right. So it doesn't mean that it's necessarily going to happen. I could name, a member of the royal family as guardian of my minor children. Doesn't mean it's going to happen. All it means is that I wish, that this would happen. A more realistic choice is going to be, your loved ones, the people you trust that are around you and your minor children. And so you're going to put that in your will. If you don't, and people don't have a good idea of who would you want your children to be raised by, when you are intestate, family members can kind of fight over that and say, oh, I think she would have wanted this. I think she would have wanted that. And you may wind up in family court to say, who is raising these children? And you might have family members kind of fighting over that. If you have a will that says, here's my first choice to be guardian of my minors, and if that person won't serve, here's my second choice, the court is going to honor your wishes because it's been put in a will. They're going to give a great deal of weight to that. So that's an important issue. That's another reason to have a will. So, that's a response to people who go, oh, I don't own much. It doesn't really matter. Well, if you have minor children, you absolutely want one. The other thing is that you can make sure that minor beneficiaries receive things, or frankly, any other kind of beneficiary who needs to maybe be protected from themselves if they've inherited money. You set up things like that in your will. If you don't, so I'll give an example. Number one, someone has special needs of some kind, they're not going to be able to handle their own money themselves. And so maybe you want to set up a trust. There's a million different reasons to set up trusts for beneficiaries. That's one of them. Certainly if someone is a minor. Now, again, it's not just under the age of 18 anymore. You could have a 24-year-old and you're probably still going to be fairly hesitant to just be leaving them, proceeds of a life insurance policy outright. That's a fair amount of money. You probably want, at least at some point, until that younger person reaches an age that feels more responsible, you're going to want to put whatever they would receive in a protective trust, naming a trustee, and that trustee is going to oversee the use of that money on behalf of that 24-year-old or 21-year-old or 27-year-old. When I started practice, the age of responsibility was 18, 21, and 25. And now it's 25, 30, 35. Those are the ages now that parents and grandparents are looking at and saying, yeah, probably by the time they reach age 35, they'll have figured out money by then. Again, laws of intestacy, the only kind of protections that are in the law are uniform transfer to minor accounts. Each state has a different, has their own version of that. They're slightly different for each state. And the ages generally only go to about age 21. So, you can protect things until age 18 in some circumstances, and in rarer circumstances till age 21. Nowadays, that is not getting people where they feel comfortable. So again, the use of a will You can put things in trust for someone's life. I've seen parents put it in trust till a kid is 65, and then they at least know, well, Social Security is going to kick in for them at that time. But your plain vanilla version of leaving things in trust for minors is going to be age 25, 30, and 35, around that time. Oh, they get a little chunk at 25, they get the next chunk at 30, they get the balance at 35. That's just, again, an illustration of what a lot of people do. All right. But if you don't have a will, you can't do any of that. Okay. So the law itself doesn't give us a lot of options there. So the final issue I want to bring up here on kind of why you might want a will is the issue of step families. We're certainly, step families is incredibly common. And one of the most common scenarios I have of unintended consequences is when children call up and say, well, my dad got remarried right after my mom died. And then when he died, he left everything to his new spouse. And now she has everything and we have nothing. And that's not what we wanted. And that's not what dad wanted either, probably. Okay. So when someone just does a will and they go, well, I leave everything to my spouse, done. They don't really think about the next step and say, well, then what happens if my spouse dies? What do I want? How do I want things to pass at that point? And stepchildren, step parents are not legal children or parents under the law. So what that means is if my will says I leave everything to my children, legally, it truly means children. It does not mean stepchildren. So one, if I want to include stepchildren, if I raised my stepchildren and I view them as my own, I need to put that in a will and include them in the definition of children. On the other hand, if, people got married much later in life, their children were grown, they're technically stepchildren, but they have no intention of benefiting them. The legal definition of children under a will is not going to include them. And that may be what they want in that scenario. What they don't tend to think of is, well, I want to benefit my new spouse who is not the mother or the father of my children. But once they're taken care of, my intent was in the future, after I'm gone, I wanted it all to eventually go back to my children. A lot of people want that. And the laws of intestacy are not going to get you there. Okay. A will, however, and the use of a trust where you say, okay, I leave everything to my spouse in trust for his or her lifetime. And then at his or her death, then everything has to go back to my children. That's a marital trust. And that's the kind of thing that you can set up in a will. Okay. So this is just a smattering of all the different issues that wills address legally to make sure that all of these things happen. So I hope I've convinced you all that of course you need a will. That was probably a given from the beginning, but I want to be clear on that these are the legal issues throughout that are addressed by a will. All right. And I've also mentioned, the other topics that I did want to mention, which is, how do I leave things to beneficiaries? We've heard about trusts for minors. That's kind of a given. If you've got beneficiaries, if you've got kids who are under the age of 30, you maybe, want to look at those options, about leaving things at age 25, 30, 35, something like that. If you're in a step family, if you're married or whatever, you want to, perhaps the use of a marital trust, that kind of thing is going to be something that you want to incorporate, perhaps. Okay. I'm going to pause for just a bit and take some questions. If anyone has questions at this point, let me check the chat here and see what kind of questions we have, and I will make sure that I address anything. Can your lawyer also be your executor? Sure, they can, if they agree to it. Lawyers serving as executors it tends to be something that I view as a previous generation of lawyers is what they did. That the lawyer used to be the executor, and then that was the first choice. That's very rare anymore. Because what we have found, and again, I've been practicing 22 years, so I'm sort of in a in that generation of attorneys where that was ending when I was beginning practice, because family members and loved ones will sit around and kind of look at the lawyer and say, how did you get in there? You know, and it feels self-dealing in some way. It isn't, but for some reason people have a more of a distrust of lawyers or something kind of than they used to. It used to be like, oh, the family lawyer, you know, we rely on that person for everything. And that, you know, we're just living in a different kind of society now, which is fine. So no, they absolutely can be if you want them to be. They don't need to be, and I don't really see it that often. Okay, what is the document we can fill out without hiring a lawyer? It's called a will. It's called a will. Okay, so yes, you can go to, you know, Office Max, and they will have form wills that are specific to a certain state. Okay, so you want to make sure that it's for your state of the state in which you reside, but it's called a will. Okay, whether you've got a lawyer or not. Can you override these matters by providing for a transfer on death or designated beneficiary? Yes, and we're going to talk about that next. I will get into titling and how that changes things. Adult man, only child, mother died intestate. How does he access her TIAA retirement account? That's a pretty specific question. The short answer is, what's the beneficiary designation of that TIAA retirement account? That's who it's going to pass to. I'm going to go over titling of things in a moment, so I'm going to skip over any questions that will sort of be answered by default. What do you recommend to protect a state if marriage is on the rocks? I'll get there. I'll answer that. That's not quite what we were just talking about. Does he get as much Social Security? I'm not answering that. Do we still need a will if we have a trust POA already? Yes, you absolutely need a will for all the reasons that I've talked about, and I'll touch on revocable trusts also. All right, why don't I move on? I think a lot of these questions are going to become evident once I continue here. Okay. All right, let's talk about advanced directives. Okay, so if someone is incapacitated in some way and cannot act for themselves, we have two other concepts that we want to make sure that we have in place. So for me, a complete estate plan is everyone should have a will, no matter what else they have. Okay, so that answers that one question. Even if you have a revocable trust, all those things, you absolutely need a will. You need a medical directive and power of attorney, and you need a financial power of attorney. Okay, those three things will cover all of the bases, the basic bases for you. So every human being is going to have those three things in place at a minimum. Okay, you might have a lot more than that too, but those are your three basics. Okay, what's an advance directive? An advance directive is the thing that says, if there is no hope for my recovery, I am in the process of dying, what do I want to happen? Do I want to be kept alive from extraordinary measures no matter what? Or do I want to be kept comfortable and allowed to die with no extraordinary medical measures being taken? So in other words, we know this is a living will. We know this is pulling the plug in casual terms. Write it down. What would you want to happen? And I'm telling you, 99% of the people walk into my office say, keep me comfortable and pull the plug. And 1% of people walk into my office and say, I want you to do everything in your power to keep me alive. There's no right or wrong answer here. What do you want for yourself? And you're going to write that down. All right. There are forms for this. Every single state has a form. And if you go into a hospital for any procedure, they will sometimes hand you that statutory state form and say, do you have a living will? Which always makes you feel great when you're getting like a colonoscopy or something. You're like, really? A living will? Like, what's going on here? Don't freak out. It's just policy. Fill it out, and it's going to ask you these questions. It is an expression of wishes only. There is no legal effect to this whatsoever. The reason why you have this is that if you did not have this conversation with your loved ones of what would you want if this horrible thing happens, then at least you have expressed your wishes somewhere. So who really benefits from this is your loved one sitting around you, that if the medical community has to turn to them and say, okay, we've done everything we can, there's no way this person is recovering, what would she have wanted? It's so that your loved ones don't sit around staring at each other going, I have no idea. We've never talked about this. And I'm going to feel so guilty no matter what I decide. If I say, treat her no matter what, I'm going to feel guilty that, she's been dragged out through suffering. If I say pull the plug, I'm going to feel like I killed her. This is really to make your loved ones' lives easier should a very difficult situation arise. Okay, that's advanced directives. All right, and I'm going to cover powers of attorney also, and then I'll take questions. Powers of attorney. A power of attorney is a legal document that names another person that operates on your behalf if you are unable to do so, or even if you don't want to do so. Okay. So a financial power of attorney is the thing that says, I name so-and-so to just handle my finances for me in the event that I cannot, or even in the event that I will not. This happens while you are alive, okay? Powers of attorney end at your death. Upon your death, your will and all those other things come into play, but a power of attorney is purely during your lifetime if you are unable or unwilling to handle finances or medical decisions. So obviously, if you're conscious and someone is asking you about your medical care, you're going to answer, right? And you're going to handle that yourself. But if you're unable to, if you're unconscious or unable to handle your medical decisions, you're going to have a medical power of attorney, and you're going to name someone who says, I want this person to speak on my behalf when I can't. Okay? So will, medical, and financial power of attorney, and part of that medical is going to be that advanced directive, the living will portion that says, oh, and by the way, if I'm in this really specific scenario, I either want to be kept alive or not. Okay, you're going to make that statement in there. Okay, questions on just that. Okay, I just want to take the questions on the powers of attorney. Okay. All right, I don't think we have questions on that in the chat. Okay. So someone, for instance, brought up, okay, my mother passed without a power of attorney. So again, I want to stress the power of attorney is not for anything after death. Okay. The power of attorney is only while you're alive. Okay. As soon as you die, your power of attorney disappears. You don't need it anymore because then your will takes over. Your will and all of the laws. And if you don't have a will, the laws of intestate, that's what takes over at that point. Okay. And so you're naming an executor or you're getting that administrator named, that's going to be the person who's then going to handle everything going forward. Can someone from a different state be your power of attorney? Absolutely, they can. Yes. What is power of attorney versus guardianship? So a guardianship is where you are, there is someone who needs someone to act on their behalf, but that someone never did a power of attorney. Okay. So powers of attorney for a lot of people are actually more important than a will. And the reason why is because the result of not having a power of attorney, but needing someone to act on someone else's behalf means a trip to the courthouse, and it means a petition, and it means a hearing, and it means this whole process to get someone else cleared by a court to act on another person's behalf. Okay. Now, sometimes if you have, for instance, a special needs child or someone who does not have legal capacity, or even an adult who does not have legal capacity to do their own power of attorney, then you need to do a guardianship proceeding, However, as long as you have legal capacity, get that power of attorney done, because once you are then no longer have legal capacity, if someone develops dementia, for instance, they get to a point where they can't sign any legal documents anymore. There's nothing that can be done except if someone who wants to act on their behalf walks into court and tries to get authorization from the court. That's a whole big process. Okay. I have an advanced directive, but I would like to add an addendum for more specific wishes and instructions. How should I do it to make it legitimate? It's a writing. Okay. So you add on to it yourself, however you want to do that. Put it in Microsoft Word and add a second page or something. As long as you sign it, I would get it witnessed. In most states, it does not need to be notarized. Okay. But I would absolutely date it, sign it. I would do it in front of at least 2 witnesses. But an advanced directive, like I said, it is not a specific legal document. You can write down whatever you want. I have a client who wanted to be kept alive in all kinds of various scenarios, and she wrote 4 pages on it. That's her advanced directive. So you can write these things yourself. The advanced directive part, nothing else I've talked about this applies to. But because the advanced directive is just an expression of your legal wishes, you can just write it out however you wish. Give copies to your loved ones, date it, sign it in front of a couple of witnesses. That is a perfectly legal document. Okay. Power of attorney also is a Staples form. Yes, absolutely. You can get a power of attorney at Office Max, whatever the office supply stores are. They are there. Okay. All right. Let me see. Do we have any? If we have any audio questions, I'm happy to take those. I'm not really sure how to do that on the settings, but all right. Let me jump onto our next topic so that we can be clear on this. Okay. So let's talk about assets. So we talked earlier about how things pass through our will. So here's a big surprise. Not everything we own passes through our will, and our will does not govern everything we own in the world because certain things are titled in different ways. Okay, so I'm going to go over that. First of all, what are our assets? What are our debts and liabilities? The first step in any estate plan is to inventory these things. And this is any attorney that you would ever meet with is going to hand you what I call the dreaded questionnaire. And it's going to be like 12 pages long. And it's going to ask you like every shred of financial information and personal information you could ever dream of. You might as well, if you haven't put together anything yourself, get started on it now. Okay. List your assets. What are your assets? Cash, securities, real estate, retirement plans, life insurance, annuities, any interest you have in a business, tangible personal property, which is like stuff. It's this mug is tangible personal property. It's my desk. It's my computer. It's the stuff in your house, the furniture, the clothing, the jewelry, things that aren't in a financial institution or in a bank somewhere, or it's not your house. That's real estate. Tangible personal property is the stuff. Okay. This is a list of all of the things. They are all considered assets at your death. So yes, even the qualified retirement plan, even the life insurance, those things that for some reason, a lot of people don't think that these things count as assets. They all do. Okay. What are your debts? Mortgages against your real estate. Home equity loans, student loans, credit card debt, auto loans, business loans, money that you owe a friend, who could, if it's in writing anywhere and they can, show up after your death and say, hey, he owed me $200. If it's in writing, it's a debt. Okay. List all that as well. All right. And list how all of these things are titled. All right, let's talk about titling. This is really important. There are 4 categories of how we title our assets. The one is beneficiary designation property. So if you have things like retirement plans, life insurance, you have filled out a beneficiary form at the end that says, okay, at my death, the life insurance proceeds get paid out to my children in equal shares. Or, my spouse. And my second beneficiary is my kids or my mom, whatever. But you actually fill out a beneficiary form. that asset does not pass through your will at your death, okay? It goes by way of the beneficiary designation. So the next step in putting together any kind of an estate plan and figuring out what you need is to write down the titling of all of those assets and debts that you just wrote down. Same so let's talk about joint property. Do you own your property with someone else? Is your house owned by you and your spouse together? If so, it's probably titled as joint with right of survivorship, or joint tenants, or tenancy by the entireties. Those are all different ways of saying joint property. And what that really means is that if one of you passes away, the survivor of you automatically becomes 100% owner of that property. So it could be a house, it could be the investment account, it could be the checking account, whatever it is. If you own it jointly with another person with rights of survivorship, it automatically passes at your death to your joint tenant, the person you own it jointly with. It does not pass through your will. All right. So again, you're going to list your assets, you're going to list your debts, and you're going to list how those assets are titled. You're going to list how those debts are titled. Is the mortgage in both of your names? You know, if your house is owned jointly, is your mortgage also joint? Or is it only in one of your names? Is your credit card in joint names? Is your credit card in your name alone? That makes all the difference in the world. Okay, so you're going to write down how things are titled, assets and liabilities, and then you see how things pass at death. And then you can decide to change those things around, or you know, that all of that is taken into consideration when putting together a comprehensive estate plan, so that everything you own in the world, no matter how it's titled, winds up with exactly who you want it to wind up with. Third category, property and trust. I'm not going to talk about this too much. There are people out there with revocable trusts. Revocable trusts are absolutely can be a vital part of an estate plan. It, you know, most people in the population are not going to have a trust of any kind. But again, if any kind of property is in trust, note that. And then the terms of the trust are going to say what happens to this property when this person passes away. So the trust document itself, similar to a will, says this is what happens to this property when someone passes away. Okay, so those are the first three categories: beneficiary designation, joint, and property and trust. The fourth category is the category called probate property. That's the category that passes through someone's will. There's an asset. It doesn't have a beneficiary designation form. What do we do with it? It's not held jointly with anyone else. There is not a trust affiliated with this property. What do we do with it? It's probate property. Did this person have a will? Then it passes through their will. If they didn't have a will, then it passes by the laws of intestacy that we talked about in the beginning. Okay, so those are the four ways that property can pass. You're going to write this down, and now you know how your particular property and liabilities are going to pass at your death. Who's going to be liable for those debts, and who may already be receiving assets at your death, even if you don't have a will there. Okay, so this kind of throws, you know, a little bit of complexity in for people if they just thought, oh, I just do a will, I say here's who gets it, and then we're done. Unfortunately, the law doesn't work that way. Okay. All right. Questions on that? I know I'm going up against our time here, but I do want to take questions so far. Let's see, chat. I don't really understand. So debt passes own. I don't understand that. I may move to another state due to employment in the next 2 years. Would I need to do another will in the new state I move to? In general, no. It's always good to check to see if there is state-specific provisions that you want to put in a will, but it does not render your will invalid or anything like that in a state. Not at all. You've still got a perfectly valid will. Should I have a transition will? I had one when married. Now we're in the divorce process. I don't want everything given to my husband. Yes, you can absolutely have a transition will. Every state is a little bit different as to when they determine someone is divorced, and that can actually change. Pennsylvania changed its law a few years ago that it used to be as soon as you filed something, boom, you were considered divorced for estate purposes. And then they changed the law that then you weren't. So if you died mid-divorce, your executor basically had to finish your divorce on your behalf. So yes, if you are in the process of divorce or thinking about it, you can absolutely have a will in the meantime that like takes a spouse out. What is an irrevocable trust? I'm just not covering that on this. I'm happy to answer that question outside. I'm just not covering that on this one. For the brokerage accounts, is it better to put in the trust or just pay on death? Thanks. That's a great question. It totally depends on your particular circumstance. So I will never give advice that says, oh, everyone should just rush out and change their assets to be titled in a certain way. It is absolutely specific advice for each and every client. It depends who your beneficiaries are, how you want to leave things, what type of asset it is. That's a minefield. So it just really depends on your own scenario. If the debts are greater than the assets, you have an insolvent estate, and there is a process in each state for that to make sure that the debts are discharged off the top and that in the order in which the law says that they should be. Okay. What's the benefit of having an estate lawyer? Can they be outside the state of residence? Yes, they can be outside the state of residence in general. They may need to use lawyers in the state of residence just for any state specific level of things. But, I do a lot of like federal work. And so it doesn't really matter where my clients live. So it's not an absolute rule that they have to be in the state of residence, but you need to be sure that you're not practicing in a state in which you're not barred. Okay, so that's an issue out there. Are family trusts commonly used in New York State? I would say, yeah, it totally depends on the scenario, but sure, family trusts are used everywhere. Okay. And then what's the benefit of having an estate lawyer? Well, because they know all this stuff, right? I mean, like we just went over asset titling. Most people have no idea about that. And so they think that assets are going in a certain way and they're not, and that's not our fault. Like we didn't invent that, that's just the law. So we try to navigate that for other people. Okay, I'm just really mindful of my time. It's been 45 minutes and I know we didn't cover like a lot, but we kind of did cover a lot at the same time. Let me just see if I can. Okay, I went into more detail about each of the kinds of property, but I would say this, a really great start to having your estate plan is mapping all that out, is listing your assets, listing the debts, and actually seeing, who things are passing to. And then the probate property, the fourth category is the only one passing through the will. And then your will has to say, how do you want that property to pass? Okay. We did not get to fees or taxes. There's a probate fee in every state. Most states, probate fees are pretty high. In the Pennsylvania, New Jersey, New York area, they're actually quite low. The use of a revocable trust can be used to avoid probate. Certainly in most states, someone with over a certain amount of assets might want to look at using a revocable trust to avoid probate fees. But here's an example. State of Pennsylvania, you can have $1 million of probate assets and your fee's only going to be $1,300. So it's not a big deal, but in most states, it is a big deal. Many states have an inheritance tax or an estate tax. And there can be some planning to be done around that to minimize that kind of tax. The federal tax this year is 11.7 million. So you're not subject to federal estate tax unless you're quite a wealthy person. And even then, if you reach that, you are there's plenty of planning options, you know, and absolutely you would need an attorney for that level of planning, and that tax can be minimized as well. So that's a really quick overview on that.